The main difference between a living trust and a will lies in when they take effect and how they manage assets. A living trust becomes effective immediately upon signing and funding, transferring assets to the trust and allowing a designated team to manage them according to one's wishes. This approach avoids probate, saving time and money, and potentially keeping the distribution process private. In contrast, a will only becomes effective upon death and must go through the probate process, a legal procedure where the court validates the will, oversees debt and tax payments, and ensures proper asset distribution to beneficiaries. A living trust is generally more accessible and less time-consuming, with lower complexity, but often comes with higher initial expenses due to legal fees associated with drafting trust documents and transferring assets. On the other hand, the cost of drafting a will varies depending on complexity and the level of involvement of legal professionals. While wills may have lower upfront costs, the associated probate process can result in additional fees and expenses, making them the cheaper option in the short term. In terms of flexibility and control, a living trust allows for greater management and distribution of assets, both during one's lifetime and after death. The trust can be amended or revoked as long as the individual is mentally competent. In contrast, a will provides instructions for asset distribution but offers less flexibility, and can only be updated or revoked by the testator before death, as long as they are mentally competent. Despite their differences, living trusts and wills share similarities as estate planning tools designed to convey one's wishes. Regarding asset distribution, both enable the appointment of someone to manage asset distribution, known as the executor in a will and the trustee in a living trust. Ultimately, the choice between a living trust and a will depends on individual circumstances. Living trusts offer greater privacy, as they do not become part of the public record, and provide flexibility, allowing the grantor to make changes to the trust document and appoint a successor trustee if needed. Wills, on the other hand, are generally more straightforward.